back to another edition of the Dirty Verdict podcast, No Sneeze edition. Also dark light edition.
It's
Dark suit edition, except for me.
It's a sensual feeling in here. I'm not going to lie.
Yeah, so I'm one of your hosts, Peter Taaffe, joined as always by co-host Kyle Herbert.
That's me.
Bill Ogden. Thanks for joining us, guys.
Always happy.
And
joining us. Thank you for joining us.
Yeah, I'm sorry. Thanks for being here as always.
Yeah.
And we are joined again by a frequent guest that we're always happy to have, and that is Anthony Osso. Thank you for joining us, Anthony.
Thanks for having me.
You're the feature artist on our album. True.
Good to be
Yeah, if this were like Saturday Night Live, you'd probably at five.
Mm-hmm. You're like our Bill Hader.
Yeah. Like Paul
Simon, but you don't have any idea who that is.
It's like Paul Simon back even older.
Yeah.
So if Anthony's here, that means we're going to talk a little true crime.
Okay.
Bump, bump.
So Amanda Orr helps us find these stories, and we're going to, I hope we're going to talk about one that involves a husband and wife, and where the wife's murdered, that's developing in San Antonio that I have a little bit of knowledge of, but that's kind of early. This one's very similar to that.
Before we get in, shout out to Amanda for always giving us like super gory, horrific stories to talk about. I mean, I don't know what she does in her spare time, but it sounds, ugh.
Yeah, this is not the feel-good story of the summer.
No. But if you're looking for any PR or strategy group.
Well, it was so this was, unfortunately, this happened in 1999 is when this.
This is a millennium old.
Yeah. How old were you in 99, Bill?
I was 12.
Okay. So, and
Peter was 71.
Yeah, I was like just turning.
Peter was just able to grow a mustache.
Mm-hmm.
Almost. So, okay, 1999, this is a case of David Temple as the defendant. So what I'll do, guys, is I'll try to give a high-level overview. And obviously, Anthony is here to answer questions or give commentary on the criminal defense, criminal prosecution side of things. And I don't know what exactly y'all plan on doing.
Talking about all the sexual stuff.
Got it.
I'm going to sit here and look very attractive for our YouTube followers. And otherwise, I plan on not contributing it.
Follower, but yes.
All right. So David Temple was I believe, a college football player who had gone on to become a high school football coach, I believe in Hastings, or he's from there, but this all happened in Katy. So his wife is also, Siri wants to be involved in this. His wife was also.
I don't have an answer.
Jesus, Peter. Trying to be a professional.
She does not want to be involved.
No, thank you, Siri.
All right. Call sneeze and Peter's talking to a robot.
So in 1999, David Temple, his wife works with him at the school, is also a teacher. She's pregnant. They have one child who's 3 or 4 years old. She comes home. Her child was sick. She had to go get the child at school, came home, and she's late stage pregnancy, so she's not feeling good. David comes, takes the son, drives him around to run errands, kind of get out of the house so she can rest. Comes home and goes to various different places along the way. Comes home at 5:38 p.m., finds her dead in a closet, had been shot, came around, it was a shotgun to the head, and found her, calls 911, and there we go from there. So it appears on its face to be a break-in. There's a lot of facts that we'll get into that ultimately led police to believe that he was responsible. So interviews are done.
Mm-hmm.
All the witnesses are interviewed. He's interviewed. Nothing happens for about 4 or 5 years. At some point, the investigation is renewed, and he is ultimately indicted, tried, convicted, and punished with life imprisonment. His lawyer was Dick DeGuerin, world famous criminal defense lawyer. The prosecutor was is it Kelly Siegler?
Yes, yeah.
Kelly Siegler, very famous prosecutor at the Harris County DA's office, goes up on appeal, or at some point it's appealed, and Anthony can help us with the terminology on the procedural. Ultimately, there's a hearing, a 2.5 month hearing, where Dick DeGuerin and another very famous defense lawyer named Stanley Schneider argue a case to a judge named Larry Gist, or Gist, Gist. He ultimately finds, and that judge finds 36 instances of prosecutorial misconduct, most of which I believe were...
It's got to be a new record.
Yeah, well, I don't know. Who knows? But most of them were involved with what we call Brady violations, meaning the obligation of the prosecutor to disclose evidence,
Exculpatory
evidence.
A couple of buzzwords from law school.
Excellent. To the defense. And that was then also bolstered by in the interim, the Michael Morton Act was passed in Texas, which kind of, I think, enhances that.
It does.
A little bit. So he's retried, reconvicted.
Wow.
And the jury is hopelessly deadlocked on the punishment phase. And then there's a question on whether the whole case has to be redone because of that, or if, or how that works. Ultimately, the court says no, send it back to I guess another jury for sentencing. They also find him life imprisonment, and that's where we are now. And I assume he's still appealing that. So
I'm sure, yeah.
Okay, so couple little sub details. So after he finds his wife, obviously the police come in and do a lot of interviewing of people. Obviously, they didn't. First question, Anthony, for Anthony. If you find your pregnant wife deceased in your house, no matter what, no matter if you were like, no, I have 50 people, I was at church and they can all say I was there, would you recommend having a lawyer present when you were questioned by the police?
Asking for a friend.
Absolutely. But I'm a defense attorney, so I would advise that.
Yeah.
Is there any benefit at all to answering questions without an attorney in that instance?
I think if you weren't there and you didn't do it, and you come in and you find your wife and you're not a suspect, then I don't think that there's a problem in calling.
Are you always the suspect, though? I've seen the first 48.
I don't think you're always a suspect.
I mean,
he wasn't the first suspect in this investigation.
And now he's spending the rest of his life in jail.
If he talks to the police without a lawyer.
Right. That's the point, right?
I think it's, yeah, I think when the police get there, you definitely want to, and I'm not telling you how to commit or not commit, a crime, but
we're all innocent here.
If you find your wife with a shotgun wound to the back of her head in the upstairs bedroom of your house and you had nothing to do with it, then you better damn sure look like you had nothing to do with it when the police get to that scene. And I think
change your face. I think
I got a guilty face.
I don't know that you need to lawyer up the minute that the officer asks you what happened if you had nothing to do with it. I think, but in his situation, when you did have everything to do with it, absolutely.
I mean, so that's my next question. I don't know when do we get this data, but like, what is it that ties him to the murder? Or if you have a plan for revealing this.
So I can send you if you like. There's about an 80-page opinion on very detailed facts. So remember, for 5 years he's not indicted.
Right. Well, what happened after 5 years?
That's the question. Apparently, the guy in California that Scott Peterson, I think was who it was. That was a very high profile. That kind of renewed this.
Lacey Peterson's husband.
I think so. Yeah, that renewed this whole interest, and apparently, the deceased parents never gave up and kept pressing and pressing.
They knew it was the facts were like spitting image. It was like two educators. He was having an affair with somebody else. I don't know that she was pregnant, but
yeah.
And they called Chuck Rosenthal, the DA at the time, were like, why are they getting justice in this case? And we've been waiting for 5+ years to have it done in this case.
So a deeper dive was done on the facts. So if you look, this opinion that I read last week is very detailed. Like his story, ultimately, once it got dug deep into, like everyone, the police apparently questioned everyone and took everything down, but no one like really looked for inconsistency. This is all circumstantial case, right? Because
so he wasn't really with his son running errands.
No, but a lot of his timeline that he gave didn't confirm with. He was in the Home Depot for this period of time, and he went to one park and then he went to another park, and that didn't really make sense. So he started having a lot of holes in his story, and just little things like nothing was stolen from the house, even though there was like a watch there and very expensive items.
Well, and I think what happened too, and to go back to his earlier question, there's a difference in an officer asking preliminary questions on the scene. Like you got to think. I imagine at that time there was a break-in. There's probably a suspect at large with a shotgun. So
killing people.
Yeah, potentially killing people. So if you're really innocent, then you'd want to offer whatever evidence you could as fast as you could to stop that. But like The minute that you're asked to go down to Travis and make a statement,
my name's Detective so-and-so,
then I think you're well within your right, and you should, legal advice, you should lawyer up. And that's not to say that you don't cooperate with them, but you just get the advice of counsel before you go in and make the statement.
I don't pay a parking ticket without counsel present.
That's good.
Okay.
And go out. They
had that initial interview, Peter, and then I think that when they took what Temple said, go back and look at the crime scene, they're like, no, this didn't really add up. They have a second interview with him where they're like, well, why don't we just do a polygraph? If your story really checks out. And he was like, screw that, I'm getting a lawyer. Which I don't think
that's not bad. Do it.
Yeah, I think absolutely. Like if at the minute you become a suspect, I don't think that's shady to ask for a lawyer at that point.
I don't think it's shady to ever assert your constitutional rights. I agree.
Don't
make that patient, Bill.
That's always the line too, and this is amateur criminal hour. Like, but this is kind of criminal 101. At what point does the police officer need to read you your Miranda rights? I mean, along the way, they should know. Like, let's say this police officer knows, hey, I found the gun under the car, but he's asking you questions. Like,
doesn't matter.
Shouldn't the officer tell you, hey, guess what? I got you slammed.
The officers should do a lot of things, but that doesn't mean they're going to do that.
When is their obligation?
Well, I don't think he has to in that situation.
No, he doesn't. Officers can lie. They can say things that aren't true to bait you into making it.
It's only when you are detained that they're required to do that.
Yeah, and it's really the magic word. Detain is the magic word they try to use. Is if you're not really under arrest, you're just being detained. But that doesn't necessarily mean you're not under arrest. So your Miranda rights are triggered once you are under arrest. And so I think if you're in cuffs in the back of a cop car and they say you're detained, I can still turn around in a court and try and suppress the statement because I'd argue you were under arrest.
For sure.
It's just,
or if you're to leave, if you come in voluntarily into the interview room, and you say, okay, I got to pick up my kid, and they go, no, you can't leave. Then you're detained.
You are not free to leave.
Then you're under arrest. So you would say for some of that situation, force the issue and go, I'm leaving, make them,
or just say nothing. Yeah, and if they won't, just don't. You can assert your right orally. You say, I refuse to answer any questions. I'm asserting my Fifth Amendment right to remain silent.
Okay, I just go nah.
But I look him right in the camera and I go, have you talked to Bill Ogden yet?
This is Dave Chappelle, Fifth.
Anytime a cop asks me a question, I go,
yeah.
So hate it. So y'all had asked, what happened. So obviously another group took a deeper dive into the facts and all the investigation that had been done, found some holes in his story. Other ones I saw were like, they had this vicious guard dog, but to the extent the cops couldn't even get into the house
without the guard dog.
They were about to shoot the dog because they knew there was a victim. They didn't know whether she's alive or dead. They're trying to get in there. They're on the verge of shooting the dog, and the husband comes home and gets the dog locked up. And they're like,
how did somebody escape this vicious animal?
How did this intruder get in? 1, 2, this is like in the middle of a residential neighborhood in Katy. She's found at 538, so she's killed someone.
People might have seen her.
Yeah, who's going to rob a house
in Katy
with a vicious dog and not steal anything at 5 o'clock in the afternoon when kids are coming home from school and everything?
So as a resident of West U, there are many softer targets than that.
Yeah. And then, of course, the other thing comes about. He's having an affair with a fellow teacher. In this intervening time between crime and indictment, they get married. He's going on with his life. And so there's just...
How long did it take for him to get married?
I don't know when exactly they got married. I know they were married at the time of second indictment, which was about 5 years later. I think it was fairly close in time after the death of his first wife.
But I think a lot of the relationship evidence, especially from a legal standpoint of what is actually going to come in during the trial, you're pointing to nature of the relationship evidence. So in murder cases and then assault family violence cases, you can get into evidence that goes towards the nature of the relationship. I think they were exchanging emails while at school, talking about each other. She was pregnant. The victim was pregnant with the
his child.
Yeah, his child.
He was fertile. Okay.
Mm-hmm. He was.
And there was some testimony about him confiding in a friend that he may leave his wife for her. He didn't know.
Yeah.
So there's like a lot. This is a classic circumstantial.
I think like the emails were even further. Like I think that there was another guy, Quentin, that was also a teacher. They both liked Heather.
Yeah.
Right. And they're both simultaneously emailing her. They're in the same room.
Every time I hear stories like this, I just think to myself, we didn't have any Heathers as teachers when we were growing up.
No, I didn't have a Heather.
There was not. I had Miss Simon.
The
the paramour is named Heather something.
Yes.
I don't know if you can call him that, Kyle.
No,
Paramour.
So I was pretty impressed with what the level of investigation the police did at the time. And this is before we had cameras everywhere. Yeah. There were some cameras at the time, but
is this Katy PD or is this?
I guess so. Maybe Sheriff's Department helped out.
HPD probably had homicide go out there.
Was it Harris County?
It was probably Sheriff's Office.
It's in Harris. Yeah,
it was Sheriff's.
Yeah, it was Harris County Sheriff's Office.
But they would, on a homicide, you're going to have
lots of
SO will step in.
A lot of black lights.
So this might sound like a dumb question. Now that we all have a global GPS system attached to our body at all times.
Mm-hmm. VPNs, man.
Is it just impossible to get away with murder now?
Well, what's worse, the fact that if you leave your phone at home,
isn't that incriminating?
Gone in the middle of the night. Yeah, is that more incriminating than having been out with your phone?
Yeah, he was on his phone nonstop for the last 30 days, and then he left it at home.
I don't know. I think it's
great. Now I can't decide if I want to take my phone or not when I'm doing the murders.
Right. Yeah, it's tough.
There were also advances in DNA type technology. I think there's some issue
they didn't have the murder weapon.
Yeah, he did.
And that's why I think when you really look back at the importance of the affair evidence and the motive evidence, you had no physical evidence tying him to that scene, except for the fact that he lived there and a couple of recordings. But I think this was all about a timeline and narrowing down
where he was.
So you think he's not guilty? You're Team David.
No, I'm not Team David.
Sounds like you're Team David.
Mm-mm.
So, so nothing is stolen, even though there's plenty of stuff there. So there's
what kind of expensive watches does a teacher have in 1999?
The big thing too,
Casio.
Yeah, right.
What kind of watch are you wearing right now?
They paid. We're going to talk about it. Hey, well, able to afford a good legal,
offline. I was like, they had Dick DeGuerin, who's a lefty.
Afford that
legendary defense lawyer, and then the second one he had Stanley Schneider, who's
on the
also one of the best lawyers in town. So I was asking Anthony, how did this guy afford it on a official salary?
Yeah,
but sometimes
I think GoFundMe was here.
No, but sometimes barely at the face. In your line of work, sometimes accomplished trial lawyers will take a challenging case for a reduced rate, I assume.
I'm
got a lawyer anyone
to reduce fees, but I mean, I think there is a benefit, or I think that there might be opportunity in a high-profile case. But
you would know nothing about that.
I would know nothing about reduction of fees.
What was the exculpatory evidence that the DA's office refused? Anyways, let me just ask that question.
Yeah. Okay. So, and this is a good trial strategy. Of course, when anyone watched The Practice with I can't remember the actor's name. He's on FBI now. The Practice was a show when I was young lawyer, as a criminal Boston. This spun off Boston Legal. They would always have something called Plan D, where they would always have to find an alternative theory.
Right.
Who else did it? Is that a thing?
I mean, I don't know I don't think there's a policy that says there has to be an alternative theory. I do think that it's important for investigators not to get tunnel vision, and as an investigator, I don't think you want to find evidence that corroborates. I don't think you want to look for evidence in an effort to corroborate your theory alone. I think you want to look for evidence and then put do you see what I'm trying to say?
Yeah.
I don't know if I'm explaining that clearly, but
if you're the defense lawyer, though, you need it because you're trying to create reasonable doubt.
Different.
And hey, this could have been this.
Mm-hmm, absolutely. And I think that's what, in the original trial, before there was even appeal or a writ, I think the strategy was that, because one of the big things investigators noticed is that at the break-in, the door hit sort of like I don't even know what you would call it, like a
chifforobe?
like a
Like
a bar, but it was like a wooden dresser essentially.
like a buffet. It might be a shifter.
And so they were saying that the glass, the way that it was shattered on the ground, wasn't consistent with somebody intruding in and hitting it. And so I think Dick argued that the glass had gotten all over the ground that way because it hit the buffet when they opened the door.
Yeah.
So, and then an alternative suspect.
Okay, so we've got this. So to Kyle's question, the Brady evidence was, I think, a lot around this alternative source. And there's a neighbor, a young person, 16-year-old, who apparently the wife had told his parents he was skipping school or having parties. So maybe he had access to apparently a shotgun. So he became
the alternative theory.
This is interesting. He apparently he had lied about. He said he was at school. It turned out he was at home smoking weed all day. He gave 3 lie detector tests. None of the results could be used because he was so done. He was so high that I don't know. Have you seen that before?
Well, they're not admissible.
Yeah,
so
yeah.
We don't. Yeah. And I've actually I still see lie detector tests, and all I think that does is just kind of help investigators verify whether they're going down the right path or not. But
So if I ever get called in for a polygraph, just
don't
Get
taste it.
stoned to
get
bejesus.
super stoned.
No, I've never seen a polygraph.
Fly to Colorado.
I've never seen any of the agencies here give a polygraph to a defendant and they walk away with flying colors. So I would advise against it.
Challenge
What do you
accepted.
think is the reason why they're not admissible? They just haven't been proved.
They're just not. They're not proven to be reliable.
I wrote a paper on this in college.
That's weird because the FBI and CIA require them to be hired.
Okay, so that was the big issue, and apparently, from what I've read on there's 50 opinions on this case. That a lot of information was given to Mr. DeGuerin real time during trial. Where it's like, oh yeah, we got your Brady evidence here.
Yeah.
Next witness, and that's not really how it's supposed to work, at least according to our court. So, anyhow, once that was all said and done, retried.
Yeah.
Good. What's the deal with them? I'm guessing it doesn't have to be the same jury to convict and sentence?
No, you can, like, for instance, in this case, so there was the original trial and then there was the appeal. All the appeals were exhausted and the conviction was affirmed. Then they filed a writ of habeas corpus. We talked about this last time I was here, which is essentially...
We were all taking notes, so you can quiz us.
So you've exhausted all your appeals. You can still raise certain constitutional violations, the writ of habeas corpus. And that's when they alleged actual innocence and prosecutorial misconduct, which the case flipped. They're in the retrial, like in 2019, I think.
Okay.
Was convicted by a jury, and that same jury was hung with regard to punishment. So yeah, you can have a retrial to one phase of trial alone.
So let me ask a dumb question. I'm on a criminal jury. I find Bill guilty of assault. Is the sentencing binary? Does the prosecutor get up and say, give them 10 years? And or do I get to pick?
You have a range.
Okay. So the judge will instruct the criminal jury, pick some amount of years.
3 to 20.
So say it's aggravated assault. In the jury instruction, it will say that you've been convicted and you face a punishment range of up to anywhere from 2 years in prison up to 20 years in prison. Then the prosecutor will argue for
A bond.
what they think is right. Sometimes they don't. There's a lot of strategy involved in, do I want to ask for a number? Do I not want to ask for a number?
Sure. Just like civil trials.
Absolutely.
You kind of plan ahead to figure out what.
As a bench, we have the same strategy, same option, kind of picking what number you think is the right one to ask for.
But it can't be 0 days.
Can't be 0 days.
Nope. Jury nullification's real. Just can't tell
It is, but that would, if they've convicted you, then they have to sentence you to a certain range or sentence you to probation.
Even if they've convicted you, they can no longer do jury nullification and say 0 years.
You can't be sent. Your minimum range on that crime is 2 years in prison.
Yeah, but the nullification means that even though I know what the law is, as a jury, we decided not to go with it.
I think that that would result in a mistrial. I haven't dealt with that issue
Because
with jury returning. Well, I haven't had the issue of a jury returning a verdict of 0 years. Like, what,
challenge accepted.
Yeah, I think that's an inch. Well, plus also you've got to think, like, a lot of times they've got the option to give probation. And so, But if that comes up,
Call me.
So this hung jury issue in this case.
Stop saying hung.
Does anybody have any idea, like, what it was? Like, was there like a group of them that was like a life in jail, and some were like, me?
No, if you read the opinion, they talk about some of the notes that were sent back by the jury for the people at home. Jurors will, while they're deliberating, will send notes to the judge, and they're usually random questions. And the judge is like, what do I say? And of course, the lawyer's like, you should tell him this.
Right.
The judge always goes, no, what to tell him. Please refer to my instructions, which are clear.
What they always say.
I have a question. So in civil trials, it's becoming more and more popular around the nation for when a witness is coming off the stand, when they're done with their testimony, the judge will break, the jury will go back. And if the jury has questions for that witness, the judge will allow them to submit them. Do they do it in criminal at all?
No.
Okay. Yeah.
Which is what you did in your Alex Jones case.
Yeah, I've done it. That's in a bunch of cases. Yeah. And I find it extremely helpful.
Yeah, I like that.
But at the same time, like, you start getting some questions, you're like, well, I don't want to waste any more time or money on experts, but I'm not winning. It hasn't happened to me, but I've heard stories.
So some of the notes back, like the last note was like, we don't know how this group of 12 people got in the same room. We were hopelessly dead. Like, it sounded like they were about to go into fisticuffs. And they were like, Judge, please put us out of our misery. Finally, the judge mistrialed the sentencing phase. And then there was some question about whether that meant the whole thing had to start over, or if that conviction on guilt
would
was
stand,
good, and then just retry. And ultimately, the appellate court said, "Yeah, you just redo, come back for sentencing."
Can sentence someone
if you didn't hear the evidence.
How will sentence someone if you don't know the?
I mean, it sucks. Just like for a prosecutor, I had a case where, like right as the guilty verdict came down, when I was a prosecutor, the defendant went into a seizure, and we had to reset the sentencing phase for like, I think it was 3 or 4 months. And I thought we were going to have to get a new jury for that. And all I'm thinking in my head is, well, now I've got to re-present all of this evidence. Yeah, I mean, I would probably streamline it more like a punishment hearing.
Plus you get additional evidence once you're in the punishment phase, right? You get to bring in prior acts and stuff. Yeah, so it's even more.
So, I would streamline it. But again, you still have to put on your key witnesses, and you've got to present a new case. And I think it's a chance for the defense bar, like for the defense attorney, to argue against the validity of the conviction without the prejudice that they might receive from the jury that convicted.
Right. 100%.
So, it's definitely not favorable for the prosecutor.
Do you ever tell your clients that? Like, hey, if shit hits the fan, have a seizure. Yeah, just do it.
Just put an Alka-Seltz in your mouth.
Have I had, would I say that on live right now?
I don't know what you're talking about.
So amazingly and dumbly enough, I was in a hearing in a probate court once, and it was going, I believe there was a lawyer who was representing herself, and 3 minutes into a hearing, she did that. Like, she faked a seizure, and I didn't know what was faked. I'm doing pretrial.
God, doing CPR.
I'm doing pretrial. This lady's there for a hearing. It gets a little bit contentious. She starts to twitch and like falls backwards into a chair.
This is all fake.
This is like in the well. And I stand up because I'm like with co-counsel going through my trial binders, and I walk over, and I knew it was weird because when she fell and started like making funny noises, the judge, like, it was a female judge who went, and then the bailiff, who's a big dude, just stood there and didn't call 911. He just stood there, and the judge said something like, "Not this bullshit again."
Again.
Yeah. And so apparently this lawyer representing herself
has epilepsy,
had tried this trick before and pretended to have a seizure. And then eventually, like, a nurse came, and then some paramedics came, and they were like, yeah, I mean, her blood pressure is elevated, but she's fine. And she's like, I want to go to the hospital. And so they took her out, and the hearing got adjourned, and the judge was piping furious.
Did you still try to put your fingers in that person's mouth to keep him from swallowing?
I had to clear the airway. Yeah, Bill, I had to clear the airway.
He's always looking for that opportunity.
Yeah, it was very strange.
That's very strange.
Because my initial reaction was to get up and help. And the bailiff was like, don't worry about it, bro. She's fine.
Yeah, I found them. Go ahead.
The judge came down, CPR, the whole thing. It was a legitimate seizure. That's
how do you know it from? You're not a doctor.
I'm not a doctor, Anthony Osso.
Quit trying. Put it on TV.
I found the note. Okay, so the last note was, Judge, Severe violence has already been done to most of our conscience to even get this far. We believe it is a total fluke, a 1 in 1,000 chance that this group of jurors was assembled. Blah, blah, blah. When 2 jurors are not willing to budge at all, there's nothing more we can do. It is best for all families involved as well as society to give someone else a try.
Wow.
We'll keep deliberating until you tell us otherwise. So after that, after reading the note, the trial court stated, based on that very well-written note, it is time that the court declares a mistrial. So that's, I mean, you've probably never seen anything that.
Never seen
pretty wild.
I mean, I've had mistrials before, but I've never seen a note like that. I mean, because, the charge that you get at the end is essentially states there will be another 12 people that will be put in the same situation that you are in and will have to come to ultimately make the same decision you have to make. And it usually.
If I'm in that jury room, I'm like,
no,
they're going to come to the exact same conclusion. We can't agree.
Right.
So
but the other 2 juries were quick to
convict,
quick to convict and quick to sentence.
Yeah. So this case, again, very circumstantial. We see TV where it's like, there's no murder weapon. You can't, they didn't find the murder weapon.
Well,
how do you attack that as a criminal defense lawyer, the circumstantial stuff?
Well, I think, and to answer your question, I think that's a huge part. The fact that the defendant's there on scene, I mean, I know there's a period in which he left, but I think that the defendant's there and that the gun is, because I think they had investigators scour the area and probably like scene help and CSU help scour the entire neighborhood, scour the entire area. So the idea that the defendant's on scene, he's the 911 caller and was able to get rid of the weapon, I'd argue that it's impossible for him to have been able to get rid of that in that amount of time. But I do think there was a large unaccounted for time period, and I think there was a witness that saw David Temple driving in the direction of a rice field. So that,
because that's Katy, and at the time, you can have a neighborhood, and then less than a mile away, you've got a rice field.
Where was Will Adams?
Yeah, I know.
So is that the theory? He hightailed it through a rice paddy, dumped it in the water somewhere. It's still out there.
Yeah, I mean, I think so. They never recovered the weapon, but I think that goes towards you talking about the circumstantial nature of the case, and you talking about the lack of the murder weapon. Like that's when you look down the road at the appeal, and like for a judge to overturn a conviction. Not only do you have to prove that there was evidence that was withheld, but you have to show that the evidence being withheld, I forget if it's probable or possible. It might even be probable, but you have to find that there was a probability that the jury could come to a different conclusion. And so it's like your harm analysis. And that's a lot greater of a likelihood when you've got a case where you don't have DNA on a firearm, you don't have eyewitnesses to the scene, and you have a legitimate, or what the defense argued was a legitimate alternate suspect theory. So just got beat that appeal up, or the writ.
Was he in custody the whole time?
No,
No.
never in custody.
He was on bond when he walked into that court.
So he was from like 07 to like 9.
No, he was in jail. Yeah, from the crime until indictment until trial.
Yeah, he was serving.
He was
life
not
sentence.
And then on a
trial two. He was in jail, I believe, until when writ was granted.
Until the writ was granted, and then he got the case was remanded, and he got a bond and was back out.
Nice.
But he was in jail for many years before.
It's called justice.
Yeah. So
a form of it. Yeah.
So
of many shades and sizes.
We kind of touched on this. The Brady law, the opinion came out at some point in time, and this Michael Morton law in Texas came out. And this was probably, this has been a while. Well, at this point in time in your practice, why would the prosecutor not just tell the defense lawyer, here is everything. I'm not hiding anything.
Yeah. It's easy for me to say now, because
weren't you there?
No.
Not 2020?
No, but at the time,
the reversal was from a 2004.
All of the alleged
bad.
So when the writ got granted, what year are we talking?
That was 11, but the trial that it was focused on happened in 2005.
Okay.
No, I think the writ got granted way later than that.
Yeah. I'm saying, but the bad acts that they were complaining of happened in 2005.
Right. So I think like you have to look at sort of the surroundings of a prosecutor in that time period. Like for me, when I was trained and I'm the product of two defense attorneys, so I've always kind of erred on the side of disclosure. But I think it's a different story in 2005. I think that the law wasn't as clear necessarily on, or at least the procedures within a district attorney's office or district attorney's offices wasn't as clear as what should and shouldn't be turned over. But, my viewpoint on it, and to anybody that's a prosecutor now, is that you err on the side of disclosure. So if you think it should be turned over, if it might be relevant, if it might be exculpatory or inculpatory, turn it over. And I think, having read I read in the opinion on the writ was that the prosecutor handling that case determined in their viewpoint that some of these things didn't amount to Brady.
Right.
And their position was, well, it's not really for the prosecutor to decide.
Yeah.
It's for the court to decide.
Right.
What a defense attorney might think is relevant and what a prosecutor might think is relevant can be two completely different things.
Now that you've been on both sides, do you have two completely different things?
Sure. No, we've talked about this. Yeah.
That's called justice.
I mean, I think at this point in time, the idea is like, if you're the prosecutor, just give them everything and let the chips fall where they may. But the defense lawyers have this ace up their sleeve. They don't have to produce. You don't have to produce anything.
Right. We don't have to produce. Well,
Fifth Amendment. Yeah.
Yeah. In state court, you don't have to produce anything. Like in federal court, when you're going to
Rule 26.
Yeah. So, but also like Michael Morton has extended. So Brady's obviously a federal, applies in federal courts, but Michael Morton has extended that Brady further, really. So it's not just evidence that might exonerate a defendant, but it's really all evidence that is potentially relevant, whether it's going to cause them to get in more trouble or more likelihood that they're guilty of a crime, or if it's exculpatory and shows they're not guilty. So
in the practical application of this, if you catch a prosecutor hiding Brady materials, is there name mud forever? Like if I find a defense lawyer hiding stuff they know that they're supposed to produce, I go on the warpath. I make their lives miserable. I bring everything in front of a judge nonstop. Is it similar? Like, do you take it personally, or you're like, what the hell?
I think that if there is an intentional withholding, like deliberate, I think that's a huge deal. Like people get fired over that, should get fired over that. But I think there's a big difference in unintentionally doing something and intentionally.
I understand that. Like I've been involved in some very complicated civil litigation where the cops did the first round of interviews, and you read the interviews and you read the notes and you read the conclusions when you finally get that whole file and you look at it and you're like, 10% of this is useful. Another 20% of it is interesting. And the rest is just bullshit, like just terrible information that has nothing to do with nothing. So I get it. Like you might get a file that's got all kinds of, Billy Joe sometimes skips school. Maybe he murdered somebody.
Right. So you get a lot of stuff that's not relevant, or they'll dump a computer that's got terabytes in it that has nothing relevant to the case in it. But I think if the question are those fighting words, if it's grounds for me to hate someone or go on a warpath against someone, it depends on, was it intentional?
How obvious is it?
And was it important to the case? Because the prosecutor assumes custody of whatever the police have. So I had a case when I was prosecuting a murder case, and I found out with a month leading up to trial that there was a missing supplement I didn't have, and the murder weapon was found on a roof at a nearing neighborhood that had never been tested for prints. And so the first thing I did was notify the defense attorney, and then I wrote a memorandum, a Brady notice, and filed it. But had I not done that, and had I just continued to operate,
you'd be in trouble.
Absolutely.
Yeah.
And I still was in trouble because it's my ass.
Sure.
I should have known about that, even though there was no way of me knowing about that. So, I mean, it's as a defense attorney, it's not our job to take it easy on the prosecutor or be understanding, but making a point to the court to try and get evidence out or better my defendant's position is different than going on a warpath against you for doing something deliberate.
Sure.
Does the DA's office, have a resource for a prosecutor who doesn't he wants to make sure they comply with Brady, they can go call ethics guy to, or gal to say, what should I do here?
They do. I mean, there's general lit. I think you have there's a pecking order, so you can ask up the chain of command to a chief or a supervisor. The problem with the district attorney's office or the life of a prosecutor, it's not to Harris County specifically, is that you're just overwhelmed with the amount of cases you have. And so it's really easy to let things slip through the cracks, or inexperience, and you don't know how to handle stuff when shit hits the fan. So, but the law doesn't care about your inexperience. The law doesn't care about.
But in a broader sense, it is the name to district. I mean, Harris County has not always had a good rap about being forthcoming with exculpatory evidence or using labs to test data that is reliable. And I think it depends. We've been through a handful of DAs since I was in law school. Isn't it the DA's job in whatever county to say, like, we take this seriously? If you need help, we'll give you help, like, to set that tone? Because I have met DAs from a variety of counties who their position is law and order dictates that I don't cooperate. Like, and I know that the Michael Morton Act, right, gives actual penalties to the person that withholds the information.
Right.
So that complexion has changed.
What is the penalty?
Well, you can be civilly prosecuted as the prosecutor.
I think you'd be criminally prosecuted.
Criminally and civilly prosecuted. I think you can lose your license.
I think the more common sanctions you see, though, are dismissal of prosecutions or suppression of evidence. I mean, those are typically what you see.
Sure.
I don't see a lot. Like, it's a lot more rare to see that a prosecutor's actually gone after. But I think,
but I mean, that was the deal in the actual Michael Morton case,
and that's what I was going to say. That was my segue. Like, that's a horrible situation.
Right?
It deliberately hid evidence that
led to the prosecution,
and a man that sat in prison for
and who was innocent.
Yeah.
Yeah.
So it's I think that times have changed, and I do think, for instance, Sean Tiers, our district attorney now, I've had the opportunity to work with him when we were prosecutors as well as when he was a defense lawyer, and I think he has every intention of making sure that Michael Morton and Brady are compliant.
Yeah, and I believe that.
So it looks like Mr. Temple was incarcerated from 07 to end of 16, and then he was released on bond pending new trial. So was that 07 to 16 to 9 years? Yeah. And then he goes back, and then he gets convicted again. So he's back incarcerated from 19 to present. He's incarcerated. He didn't get life without parole. So doesn't he qualify to get out now on parole?
So he did 9. He's got to do 30 years before he's parole eligible.
Oh,
yeah. So
I thought 30 was the life, was the life.
So the way sentencing works on murders or 3G offenses, let's talk about first degree. 5 to 99 are life in prison. Murder, you're not eligible for probation. So when you're sentenced to life, you are parole eligible at half of your sentence or 30 years, whichever comes later. So
later,
yeah.
Okay, so he's got 12 more.
I'm sorry, whichever comes earlier. And so on a life sentence,
he's 8.
Yeah, so I meant earlier. So like
he's 8 to 6 right now. So he's 14.
Yeah, so he's at another 16.
Okay.
So like, for instance, if you got sentenced to 10 years on a murder case, then you're eligible in 5.
Yeah, I got you.
So,
I'm trying to find what the current status is. I'm sure it's
the rice field's still there. I'm kind of want to go try.
Oh, that's good. So I want a metal detector. I'm sure it's been there's 10 miles of housing past that as well.
And Katy in 1999 is far different than what we're talking about.
Lots happened in.
Well, if I can go to get a metal detector out there and go find me a gun, put it up on the wall.
I'm sure some site prep for home, site.
I'm sure
it was there that would have been found.
Yeah.
Oh, so you're saying he didn't do it and that they made it up?
No, I'm just saying that I don't think it's in a rice field outside. I think it would have been found at some point. Who knows? Maybe the guy digging up
maybe he's innocent.
Could be. I mean,
that's what's crazy, right? Is that it's not like a rape case with DNA or a murder that takes place on scene. Like the argument here is based on motive evidence.
Yeah.
And
All the evidence they have against him is his story isn't watertight as to where he was.
which goes back to
And he was having an affair with a lady who was having an affair with other dudes.
right.
He was having an affair with his future ex-wife.
Mm-hmm.
Second.
And there's a lot of stuff in the record about he was saying bad things about the deceased.
Yeah, he was very emotionally abusive of Belinda, I believe. Which, and like Miles,
Yeah, but being a crappy husband doesn't make you a murderer.
Right.
does it? But if I was prosecuting the case, I would tend to lean into it. I would lean into you're having an affair, and you talk horribly to your wife. And,
Yeah, it sounds bad.
Kyle talks horribly to all women now.
but like also, there were things about that day, like in his story, the son was sick, but he took the son to the park. Why would you take the son to the park? You were supposedly going to resuscitate or help your wife that was lying dead on the ground, dying on the ground with your to-be-born daughter, and you have no blood on you. I mean, there's just a lot of things about the facts on that scene that didn't add up. And him going and talking to the homicide investigators that day, back to the first question you all asked me, was a bad idea.
Tell me what.
But
came out of that
the
interview.
difference in
Oh, it's just that it didn't add up.
Yeah.
If he just shut his mouth, it would have been better.
They wouldn't have had anything to work with.
I mean, they would have had less to work with.
So you think he did it?
I think he did it. I mean, at this point, a jury in 2007 heard the case and quickly sentenced him to life. A jury then heard it again and convicted him. And then a third jury's heard the facts of the case and quickly sentenced him to life.
I mean, I feel like that after that second conviction, though, when you're going into sentencing with somebody fresh and they're like, he's been convicted of this, like, it's hard not to get.
Yeah, I don't
life
think
sentence
that I don't know that on the second jury, they don't get to know about the retrial.
No, they get to know. I mean,
You're talking about the
sentencing,
the punishment.
Yeah,
Yeah, that's
to me. It's as if like the prosecutors get to use, like the prosecutors have to use a lot of stuff that necessarily isn't the sexiest facts and all that just to prove their case. But once they get another bite at the apple on the sentencing, they get to use all not only what was in trial, the good stuff, but then they get to bring in a bunch of other shit like the motive and stuff.
And if I'm a jury, well, you're starting at the back. You were starting on your back foot as a defense attorney. You're not. You did because like
there's no win.
You got to know that the jury probably left the trial liking Dick. I mean, it's
everybody loves Dick,
right? Yeah, set you up there. But I think on the next trial where you walk in, you're like, okay, client's a murderer. Where do we go from here?
Yeah,
you don't have that.
Ladies and gentlemen, first instruction: he's a murderer. He killed this woman.
What was the options on sentencing between life imprisonment, assuming that no death penalty, life imprisonment as the top? What is the minimum that they could have given?
5.
What do you have to do to get the death penalty these days?
What do you got to do to murder somebody and only get 5 years?
My last
Blade Runner, South African paraplegic.
So I always like in voir dire when I'm trying to qualify. Well, I'm more as a prosecutor when I was trying to like protect jurors from the low end. I wanted jurors that would give high numbers. That I would say, think of that case as the assisted suicide, where you've got an 85-year-old helping
Kevorkian.
A mercy killing.
Very different than
a sacrificial, Kyle.
Mm-hmm.
So, in your experience, pregnant wife gets murdered. How often is it the husband? Every time?
It's like 99.
I just like divorce. You can.
No, I know that's the right answer.
There's a baby.
My question is, you see Texas, any guy in Texas shows up with a dead fetus and a dead wife. Chances it was him, like 99%?
I don't know. I don't want to say that, and I wasn't there and I didn't handle the case file. I don't know that David Temple was a suspect right off the go. Like what if he had come home?
He also looks like central casting for a Texas football coach.
Have you?
I was going to say, what was Dave's team like?
Have you seen
when he came back? Because once his conviction got overturned and he had to get retried on
we're getting the team back.
Is he entitled to his job?
I don't know.
I mean, they were a big fan of him. I mean, he apparently as a coach.
I think you got to say were there.
He was. His head is like
a block of sheets.
So yeah, dude.
It is like a giant.
I can't even imagine like what size neck collar he has and tie.
He looks.
Oh yeah, he wore the rodeo.
He looks like every American history teacher I had in my entire life.
Just walked around spinning a whistle on his fingers.
Yeah. Tell you we're going to learn about the Alamo.
All right.
Herbert takes this shit to the nurse's office. This is on the Alamo.
Yeah. I had Coach Jones, Mr. Ogden.
Let me try to summarize the takeaways.
Sure.
One, if you are not happy in your marriage, divorce is a much better alternative to murder.
Absolutely.
Bruce Statement, we all agree on that?
Yeah.
I feel like we can get a general consensus on that one.
Two, if you...
Although H.L. Mencken said, for every human problem, there's always one solution, and it's almost always wrong.
Okay, well, that's
It's
whatever.
actually better than I thought it would be.
That is a friend's book.
I just read books, Peter. I just read books.
Okay, number two, if you have any sense that you may be a suspect, get a lawyer.
Get a lawyer.
Yeah.
Been hurt.
Mhm.
Okay, and let's see, what else? What's number three?
If you are in
You're a
possession of
prosecutor.
exculpatory
Yeah,
evidence.
don't be an asshole if you're a prosecutor.
Yeah, if you're number three, if you're a prosecutor,
Follow-
follow the side of turning things over.
Or just follow the rules.
Yep. Err on the side of disclosure. Disclose. That's it. There's as much justice and I don't think this applies to this case. And obviously Kelly Seeger's got a great reputation with a lot of defense attorneys. My dad is one of them. And always had a great relationship with her. She's always been great to me. So but just generally speaking, if there's as much justice in dismissing a case that needed to be dismissed than there is in getting a conviction on a case that was a slam dunk. So,
yeah, and to be fair to her, at the time this was going on, the law on that area was very unresolved, and so it wasn't as clear as it is now. So now we know they should.
So what's left on this case?
He's up
his just regular appeal on, well, he's exhausted. So yeah, his appeal, he's in the appeal process. I don't know the status of his current appeal process, but he can appeal his conviction and sentence on the new trial in 2019.
The first one was appealed for on evidentiary, like there wasn't enough evidence to convict him, and that part had been affirmed.
Yeah.
It was the prosecutorial misconduct thing that got the second trial, not the lack of evidence or insufficient evidence. So assuming the evidence didn't change, probably the same.
Yeah, I imagine that they're going to affirm, and that I don't know what a writ, I don't know if there's any writs filed, but I assume that the conviction's going to stick.
We might have to bring back Michelle Slaughter, talk about the appeal.
Yep.
For our criminal court of appeals.
That's right. Okay, well, I think we've run the gamut on this one, and Josh, bedtime is coming up. So anyhow, we'll wrap this one up.
Sounds
Anthony,
good.
as always, thank you so much.
Always a pleasure.
We obviously do not know anything about criminal law, but
I said exculpatory, that counts?
You did.
yeah, you did right off the bat, and then that was it.
Yeah, that's the only word I know.
So thank you, Anthony. You're always a great resource for this kind of stuff. And if anyone, if you're in the unfortunate situation where you are a suspect in a crime, obviously we recommend Anthony and his firm highly.
Call me. I'll give you Anthony's number.
That's right. Which is it Cogdell Law?
Your Cogdell Law Firm.
Cogdell
Still working with
Law. You can find him, Dan, and the rest of the crew over there. And for us, keep following us on YouTube, Instagram, Spotify, X, Apple Podcasts, TikTok. Bill?
TikTok now.
Oh, yeah. Well,
No.
it's back and forth. You never know. But I think as of today, it's still
TikTok's like a tariff.
Sovereign Wealth Fund's about to buy it, apparently.
You never know.
Yeah.
TikTok's like a tariff. Maybe.
Yeah. So follow us on all those, and thanks for joining us. We'll see you next week.
He's kind of looks a little bit like Mike